He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing people to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So,
Yani, Puri Kahani X Simple SI Movement SE Shuru Hodi High. Officer Light Kupish Stop Hoda High, Signal Green Hoda High, or Defendant Ka Truck Age Bodni Kubad Sita Ada Shoulder Par Chula Jada High. Koi Signal Nahi, Koi Reason Nahi. Dusri Gadian Baas Pas T. For Truck Wapas Lane Main Jerk Hoda High, Bilkul X Sudden Snapback Jaisa. Yahi wo moment the Jahan defense and Ebola, so just tapping the shoulder for a second is now a crime? Yahan legal language or common sense tak rate hain. Law kuizab se mere nanosecond be matter karta high, or defense kuizab se yes sab overreaction. Lekin courtrooms guesswork p nahi, movement or safety p chalt hain.
then any single person that ever drives mere nanosecond to the right of an improved shoulder is now violating this transportation code. The law can't be like that. Alan, for you're charged with driving while intoxicated, second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, I'll be appointed to use.
On December 28, 2024, the officer came to a stop behind the defendant's vehicle, and the light turned green, and the defendant's motor vehicle proceeded, and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated, and the officer made contact with the defendant, the driver, and so all together in the vehicle. The officer observed slurred speech, bloodshot eyes, unsteadiness on feet, and odor of alcoholic beverage. Consuming one alcoholic beverage, sobriety.
ISI drift kubad officer KO reasonable suspicion mil Gaya, or traffic stop start hoda high. Officer Gadi tak jada high or signs notice karta high jo ji shi be trained cop KO alert car deed hain, slow speech, bloodshot eyes, unsteady stance, or alcohol key strong smell. Defendant Katie High Kuwasan Surfek drink Leah the Lekin machine kuch or bolti high, 0.192 blood alcohol, Yani legal limit SE double. Is level P Yani, reflexes wapas garja chukod hain. Field sobriety test be pura nahi ho pada, or jab breath test ki bari adi high toe defendant sample nahi de patty. Finally, blood draw consent hoda high. Yes sap probable cause ka pura picture create karta high.
GN 606, the walk and turn on one extend could not be performed due to the defendant complaining of late. The defendant was read with DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license? All right. How many prior DWIs does he have?
One prior.
One? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Stewart, and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel, and he'll tell you when you have to come back. You understand?
So I need to wait for him now.
We're going to have you wait for him now, but after today, I'm going to waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence, or while he gets evidence, work the case up.
Yeah.
Right. I'm going to have you sign a reset. I'll have you meet with Felicia for bond conditions, and we'll just have you back for Mr. Stewart to show. Okay? You ready? Come on in. Hey, how are you? Mr. Stewart. What's your name?
So how is your name?
Great. We did PC on your case. Which did stand. What's your guy's name?
My last name is Alan, Your Honor. I would like to make an argument on PC. I don't know whether.
Absolutely. I'm always ready to hear it. So, refresh my memory. What happened?
So in Alan's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green.
He had expired registration, right?
No, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there were other vehicles around the vehicle before the driver jerked back the lane. So he went into the shoulder and there were other vehicles.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles.
Judge Sita Bolte High, I'm finding probable cause. Usky bad bond conditions settled Hain, or tone serious hoda jada high. Judge Katie High, AAJSE no alcohol, no drugs, no unprescribed meds. For ek or heavy condition, defendant surf interlock equipped vehicle he chula sakti high. Judge Warren Cardi High, if you're caught driving any vehicle without an interlock, your bond is gone. Police will arrest you on the spot. South High DPS KO notify car dia jada high just pura state aware ho j. Judge Ek favor be Cardi High, defendant ka lawyer home ki waja se appearance wave car dedi high, par warning clear hodi high, stay in contact with your attorney.
Compliance with the law. The only argument that the state has made here elucidated is that they observed the Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of, the safety of anybody else out there on the road. Shoulder is away from any other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegation. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to stop his suspicion information. And I would argue that there's not valid probable cause here.
He has a valid point where, perhaps he's. Well, I mean, I don't want to speculate. Like you're saying, well, maybe he did it because of this, but I don't want to speculate,
Right.
Because were there other cars? I don't know. Was it dangerous? I don't know. I mean,
but failure to maintain a single lane when there are other vehicles within the vicinity is a valid reason.
right. But you got to articulate facts as well, right? So, according to statute.
Right, and I understand because we've had this issue before where it's failure to maintain a single lane, but we're unsure if there's other vehicles. That I can appreciate and understand. But in this case, the officer did specify that there were other vehicles in the vicinity. And under Texas law, that is.
I disagree. I think that when we look at the statute to try to maintain single lanes, the second half of the statute is that it endangered somebody. And there's no indication here that there was any danger.
Was it 545.46? So, is that it?
Let me hard it.
By 45.86A, Section 8.2, may not move from the lane unless the movement can be made safely. Shall drive as nearly as practical entirely within a single lane, and 2, may not move from the lane unless that movement can be made safely. There's no allegation here that the movement is made safely.
Judge, I also have the list of, where under Texas law where it's permissible to drive on the shoulder. To stop, stand, or park, to accelerate before entering the main lane of traffic.
Let's do this. I mean, this is going to take quite a bit of more time. So can you come back? Do you have anywhere else to go? Let me go through the arraignments, get everybody done and out of here, and then because this is going to take quite a bit more time, right? Give you time to take a look more. So if you need to, you two as well. If you want to try to find case law, let me just go through. I have another lawyer that's waiting.
Absolutely.
Yeah, I'll help you out, but let me go through everything.
Yeah. Good morning.
Hey,
I wanted to reapproach regarding the PC on Mr. Allen's case. I know the state has emailed me some cases that they wanted to cite to.
Morgan.
Judge. Morning.
Someone else wanted to speak to that.
A courtroom ka most interesting moment at a high. Defense PC hearing P argue karta haiku officer kupas stop ka valid reason nahida. Wo kata high, shoulder pargati chalana Texas law cumutabik 7 perfectly legal reasons ku andar hoda high, J stopping, merging, accelerating, decelerating. Or yahan officer any ek be permissible reason rule out nahi kia. Defense ya be kata high, shoulders away from other vehicles. Law says movement unsafe hoto violation hodi high. Yahan unsafe ka ek laughs be articulate nahi kia gaya. Yani pura stop vagueness pe kara high.
Upon reviewing case law, so as we've discussed before, so he did veer into the shoulder, then go back onto the lane. And in Hardin, failing to maintain a single lane with the added vehicle component is danger that they provided in the case law that makes failing to maintain a single lane, unlawful. Furthermore, in cases such as Landing and Martinez, court added additional factors to consider for the officer into determining whether or not failing to maintain a single lane is unlawful. And one of those is time component. In Martinez, it was at midnight or at 1 o'clock in the morning. Here it was midnight as well.
No, but one of the things is there's an element of unsafety, right?
And Your Honor, there are other vehicles around. As the officer articulated in the diff, there are other vehicles around when he veered and then jerked back into the lane as the officer.
But I get it.
Then,
But where are the other vehicles? Are they next to him? Are they in front? Are they in back? He doesn't articulate it. All he says is there are other vehicles.
furthermore, Your Honor, what he did articulate into the shoulder, and upon looking at the statute for that, the Court of Appeals in Lothrop v. State articulated that there are 7 permissible reasons to go onto the shoulder, and there is reasonable suspicion to perform a traffic stop where there is not one of those permissible reasons. And here, the officer did not, with those other vehicles saying he passed the green light and then go halfway into the shoulder and then jerked back, it implies that there's not one of those 7 reasons to allow either car to pass, to stop hard, or to accelerate before entering the main lane of traffic, decelerate before making a right turn. None of those are present. None of the 7 reasons articulated in the statute of the Transportation Code 545.058 are present. So that alone, him going into the shoulder without a permissible reason, is enough to perform the traffic stop. And that taking that into account with Hardin, which he veered out of, he failed to maintain a single lane with other vehicles around, provided enough opportunity of danger to allow the officer to perform that initial stop. Man,
Where's the danger?
it would be the other vehicles present, Your Honor.
He doesn't articulate.
He does articulate that there are other vehicles.
All he says is there are other vehicles.
That is all the case law requires. He doesn't have to say there's a vehicle right in front and right next to him. The case law requires that there be other vehicles in the vicinity for it to be.
Right. In the case law,
I don't know if it's in the vicinity, though. All he says is that there are other vehicles. That's so vague. You say other vehicles in the vicinity. He doesn't say that they're in the vicinity. He just says there are other vehicles. And that's so vague and conclusory.
Your Honor, the case law does specify there only needs to be a minimal level of justification for the stop. In this case, that is enough where there's other vehicles around to provide that additional threshold for failing in a single lane. In addition to no permissible reason to enter the shoulder, there's nothing there to indicate
Right.
there is a threshold.
If we're taking outside of the failure to maintain a single lane, and we can go into the other part of the transportation code that's violated, which is veering onto the shoulder. He did not do so for one of the 7 permissible reasons, unless the officer has reasonable suspicion.
If you're veering, that is 545.060, right? Isn't that part of that's the weaving, right?
It's a different one.
Because you just said that there's another violation of the transportation code.
And it's only 545.058. It's for entering the shoulder.
May I address the court, please, Your Honor?
Hold on, let me pull that code. So that's 545.058.
058.
Transportation code.
That is driving on an improved shoulder. The operator may drive on a traveled portion of a roadway if operation is necessary and may be done safely, but only if stop, stand, or park, accelerate before entering a main travel lane of traffic, to decelerate before making a right turn, to avoid a collision as permitted by an official traffic device.
Okay.
Yes, Your Honor. So in terms of their arguments about the driving on the shoulder under Lothrop, their case that they're citing, the case itself says, and I quote, merely driving on an improved shoulder is not prima facie evidence of an offense. That's their case. It says that doesn't benefit them at all. In terms of Hardin, their own case, based on our review of the record and precedent, we conclude that the detaining officer did not have reasonable suspicion to stop at belief for violating Transportation Code Section 545.060. Again, that's their case. And in that one, that's where the vehicle's tires crossed over the fog line, just as in our case, into the shoulder. And in their own case, it says that was not reasonable suspicion. And so, I would like to highlight these two cases because I think they're directly on point. I don't know why the state did. In terms of State v. Hernandez, which is 2016 out of the Court of Appeals, and I have the appellate case number, but I don't have the specific site.
My only concern is there an element of safety?
Hey,
That's all I want to know.
To just address one point briefly, in the case Lothrop, they do say that really on improved shoulder is not prima facie means of an offense. However, explicitly that the offense of illegally driving on an improved shoulder can be improved in one of two ways. Either driving on an improved shoulder was not necessary part of achieving one of the 7 approved purposes, which are articulated in the statute, or that it could not have been done safely. And here, we're again going back to 7 articulated purposes in the statute that are not present. He entered halfway into the shoulder and then jerked back into the lane after previously having just gone through a green light. So there's no indication that he's allowing people to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So by your theory, then, any single person that ever drives mere nanosecond to the right of an improved shoulder is now violating this transportation code.
He wasn't
The
just
law can't be like that.
It wasn't just down. He went halfway in. So he veered halfway into the shoulder. It wasn't just like a little deviation. The officer said halfway.
State Bilkul City Bot Cardi High. Defendant drifted halfway into the shoulder. Other vehicles were around. No permissible reason. That's enough. State case law cite Cardi High, Hardin, Ponder, Martinez, Jahan Courts any Kaha the Kuf failing to maintain lane plus presence of other vehicles equals valid stop. State argue Cardi High co-officer KO exact distance, car positions, ya proximity detail karn key 0 at nahi hodi. BAS ya badana co other vehicles were around threshold fulfill Cardi High. Jab shoulder entry safe ya legal reason ko bag hair ho, toe stop justified ho to high.